But today we're going to talk about Supreme Court jurisdiction and how you can tell that you're being tested on that. I can come at the Supreme Court's jurisdiction two different ways when I'm trying to test that on an exam. First, I can have Congress messing around. I'm going to use terminology like that. I'm going to keep this plain language, these videos, not going to use big fancy terms. Here comes my dog. Here we go. All right. So first I could have a fact pattern where Congress is messing around with the Supreme Court's jurisdiction. I could also, secondly, have a problem with an appeal coming to the Supreme Court from state courts. So those are the two different ways in constitutional law that we really look at SCOTUS, where it's Supreme Court's jurisdiction, and test those. Now, when it comes to the broader question of federal court jurisdiction, lower courts and Supreme Court, you handle most of that in civil procedure. I'm talking here about what's tested in constitutional law. Now, if we're going to have Congress messing around with Supreme Court's jurisdiction, you look for the following components in the fact pattern. First of all, of course, it would have to be Congress passing a law. Second, you'd have to have the law taking away jurisdiction. We call this jurisdiction stripping. So it has to be a law passed by Congress, and it has to be a law that removes or strips the jurisdiction of the Supreme Court. Now, the third component is what's really important in one of these questions, and it's a timing thing. Did Congress take away the Supreme Court's jurisdiction? And of course, Congress can only regulate the appellate jurisdiction of the Supreme Court, right? Limit the appellate jurisdiction of the Supreme Court. Congress is not supposed to mess around with the original jurisdiction of the Supreme Court. You know that from Marbury versus Madison. So we're talking here about Congress regulating the appellate jurisdiction of the Supreme Court. The timing. If Congress takes away the appellate jurisdiction of the Supreme Court to hear a case before the court addresses an issue, right, in order to stop the court from issuing a judgment, there's nothing wrong with that. That's a valid jurisdiction stripping law. On the other hand, if Congress, and now we're testing the Klein case, if Congress strips the Supreme Court's jurisdiction because it's looking backwards at a decision that the Supreme Court's already made that Congress is mad about, right? So if they think about it this way, it's a future facing power that Congress has. If you don't want the Supreme Court to make a decision, you take away their appellate jurisdiction to hear that kind of a case. What you cannot do is use your jurisdiction stripping power when you're looking back and you're saying we're mad about a decision that's already made, right? And then after that, we take away the Supreme Court's jurisdiction, or federal court jurisdiction generally even, to entertain that issue. So first, it has to be Congress. Second, but I don't think this is too hard to spot, it has to be a jurisdiction stripping law. And the third component of the fact pattern is going to give you something about the timing, right? Again, was this to stop the court from making a decision, or was this in response to a decision that's already been made? That's how you test Supreme Court appellate jurisdiction stripping. Now, when it comes to cases on appeal to the Supreme Court from a state court, you know that there are multiple components to that as well. This is, again, it's pretty bright line stuff. Obviously, the first thing you're looking for in the fact pattern that would trigger this would be an appeal to the U.S. Supreme Court. Second component, you have to look at from what court. Right, for the Supreme Court to entertain such a case on appeal, it will only do that when we have a final judgment. That's another component, but from the highest court available in the state. So you look in the fact pattern, was the court, right, the lower court from which the decision is being appealed, was that the highest available court in the state? Keep in mind on this one that in most states the way this works is you start at the trial court, you go to the intermediate appellate court, and then you have to ask the state Supreme Court to hear the case. If the state Supreme Court says no, we're not going to hear the case, that is a final judgment from the highest court in a state. So you need to watch out for that. So number one, appeal to SCOTUS. Number two, from what court? You have to look at what court it's coming from. Number three, you have to look at and ask yourself what kind of issue was involved in the lower court and the state court proceeding. The U.S. Supreme Court is only going to hear an appeal from a state court on a federal question. So appeal to SCOTUS, from what court has to be the highest available court in the state, and on a federal question. Finally, the fourth component, again, is back to timing. The Supreme Court is not going to hear an appeal from a state court when there's no final judgment. So you just have to look for the fact pattern for, is there a final judgment issued in this case? So again, when I'm testing Supreme Court jurisdiction, sometimes I'll make Congress mess around with their jurisdiction. You spot that because Congress passed the law, it takes away the Supreme Court's appellate jurisdiction, and then you're looking for, was it before or after the Supreme Court actually addressed an issue. If I'm going to test you on Supreme Court jurisdiction, right, when it comes to cases coming from state courts, 4 things to look for. An appeal obviously triggers the analysis from, appeal to SCOTUS. You ask from what court, on what kind of an issue, and is it before or after a final judgment has issued. That's how we test Supreme Court jurisdiction on exams. Once again, I hope that helps. If it does, subscribe, like, do all that stuff that YouTubers love, because, you know, why not? I will see you next time for a discussion of, in all likelihood, the political question doctrine. See you then.